Yes, welcome to the No State Project here on my YouTube channel, No State Project. I'm your host, Marc Stevens. For this next hour, commercial-free, commercial-free, uninterrupted hour of Anarchy Radio right here, as we are every Wednesday, most Wednesdays. And this is episode 52 of the big show for February 21st, 2018. Libertopia 2018 coming up real soon, May 3rd through the 6th. I will be speaking again, and more important, hopefully we will be able to get a blues jam set up with the guys from Barnwell Swift. So I had some fun jam with the guys a few months ago. Hopefully before Libertopia we can get back there. So I let everyone know at markstevens.net if we're able to get that squared away. And I hope to see everyone out there at libertopia.org. Libertopia.org, so you can sign up today and we can see you there. A lot of stuff to get to. Always a lot of stuff to get to. I will be live this Saturday and we'll be streaming it right here on my YouTube channel. So whoever we're not able to get to today, definitely make sure that you call in for the Saturday broadcast. So before I get to calls, what I want to discuss here is I've been trying to get information from the Tarrant County Attorney's Office regarding the procedure for psychological evaluations. So after a week, I finally was able to speak to them again today. And what they did was they kicked the can, said I had to speak to the mental health magistrate. And so it's Nelda Cassiati. And I left a message today, although I'm not thinking it's the right number. I might have to call back and get the right number, but maybe that was just reception. I don't know. But for the actual procedure, I have to talk to them, the county attorney. So what I did was I asked some more questions. I want to still speak to one of the county attorneys there because I wanted to know, not just I want to know what the judge says to and what the judge's basis is for a psychological exam, but I want to know what the prosecutor's is. So in the case with Bao, we know that Cheryl Hardy is the one that decided that. She had some communication with the public defender and then decided to, with no input apparently from the prosecutor, to do the psychological exam. So what was interesting to me is the fact that the prosecution did not object. So one of my questions was that I want to get answered is, if it's clear that all the guy did was ask a question and there's no grounds whatsoever to challenge somebody's sanity, would the prosecutor just stand there mute and allow the judge to get away with such abuse? Or would they actually object? And because that hinges on their response, of course, to the first question. And the first question would be, is asking a question on the procedure grounds for a psychological exam, to question someone's sanity? And I had to tell this public information officer, it's kind of horrifying that it's even an issue with this office, in that you tend to think that it depends on what the question is if a psychological evaluation and questioning someone's sanity is proper or called for. Asking a question, it depends on the question. So you're gonna use one question to determine that someone is insane or possibly insane and has to have a psychological exam? The thing is, peaceful people are not imprisoned to give a psychological exam, especially when all they're doing is asking a question. It doesn't matter what the question is. You don't question someone's sanity because they're asking about court procedure. So hopefully I'll hear back. But another thing that I have, and Bao is going to be filing this complaint also, so I helped him with a complaint against Cheryl Hardy that's going to the county commissioners and is the basis of the claim against the Tarrant County Insurance. And then it hit me while I was working on this. We should not just be doing a complaint against Cheryl Hardy and those monsters at the jail. But we should also be filing a complaint, and I've already got it written up. I'm going to make this available at markstevens.net. So if you want to sign off on this, if you want to file your own complaint, you can do it also. And hopefully it's more than just me and Bao doing this. So a complaint to the, what do you call these people? The Texas, what the hell are they called? Should be right on every page. The Texas State Board of Examiners, a psychologist. And because we should be going after this SOB's license. Because not knowing, it's hard to say, it's more, look, we're certain that what the guy did was grossly unethical. At the very least, not knowing what Hardy said to him. Did he know, oh, this guy asked a question, I think he's nuts? Any psychologist who knows anything about ethics was saying, I gotta tell you, that's not grounds. That's not grounds. You don't? No. And then he did his 5-minute exam and noticed there was only some anxiety. Well, if you're locked down, away from your friends and family for 13 days, in a horrible jail cell where they're not taking care of your medical needs, you can have a little anxiety. I mean, imagine pulling anybody away from their family for 13 days, how they're going to be. Give me a... So, at the very least, what the guy should have put in his report, there was no grounds whatsoever to hold this man for psychological evaluation. He is perfectly normal, and just asking questions is not grounds. And that I am going to report you to the, at least, to the Judicial Conduct Commission, that in my professional opinion as a psychologist, you are exhibiting antisocial behavior. You put a peaceful man in jail because he asked a question? So I'll have that available at markstevens.net. It was definitely unethical because what he's doing is a psychological evaluation when there's no grounds to do that. There's absolutely zero grounds, no evidence whatsoever to think that Bao was crazy. So did he violate some of the rules of the occupation code? I would say, yeah. Fraud. For one, he is taking money to do psychological evaluations when there's no grounds to do so. Zero grounds. We don't know how many times he's done this. That is fraud. That is unethical. That is immoral. He is participating in this. That is immoral. So yeah, I think he has. All right, enough of that. Remember to go to markstevens.net, and I will have that posted hopefully today, so you can download a PDF, or I'll just link up to their form, and I'll have all the text that you can then download and copy and paste into the form, and then you can mail it. You have to mail these things. So hopefully we get a few dozen. And this Dr. And I do have in there that I think the guy lacks professionalism, that he's certainly not, that's necessarily unethical, but it raises a serious question, I think, about his professionalism. When I called as a member of the media and I wanted to ask him some questions about the procedure that the court uses with him to do these psychological exams, and he slammed the phone down. Certainly unprofessional. May not be unethical, but it's certainly unprofessional. So I do have the date of that call in there. I think it was January 29th that he slammed the phone down on me. So, let's get to, we got a new caller here. We've got area code 307. You're live on the No State Project. What's your name? Where you calling from?
This is Jeremy Lamson. I'm calling from Sheridan, Wyoming.
What do you got for us today? Good news?
Somewhat. I'm going to try the unsigned plea of guilty tomorrow afternoon. Last time I did this, it was a more criminal case. It was an assault on a police assault by a prisoner because I spit on a detention guard. But what I had done wrong is when I went into the arraignment, which I'm going to go to tomorrow, is I signed a piece of paper that said that I would not challenge jurisdiction. Didn't find that out. Went through the whole proceedings. Represented myself because public offenders are, public perfect pretenders. And I got all the way through it. And right at the end, the prosecutor brought that up that, oh, Your Honor, he had signed this. and my heart just dropped. I was like, oh man. So now I'm looking forward to doing this again, but what I'm trying to do is get everything organized. I've been watching couple of your videos, the unsigned plea of guilty, and then your last, I think, episode 52, was it your last one?
Yeah. No, the last one was 51. We're on 52 today.
51. Okay. But yeah, so I've got the whole script written down, what you went through in that video with the unsigned plea of guilty, and it kind of scares me because these judges are crazy. They're lunatics, and they will, like you said, they'll lock you right up with no problem. So some of these things,
yeah.
like where
they're not lunatics, though.
You're wrong.
They're technically not lunatics. Yeah. Because a lunatic wouldn't understand the consequences of his actions. They're antisocial, but they're not crazy.
Right.
So when you're going in tomorrow, you've actually signed a document stating that you would not challenge jurisdiction?
No, that was last time in 2016. This is a fresh new case.
Okay, good. Oh, wow, that's some... Oh, wow. Talk about a scumbag move, right?
Yeah.
That is a real scumbag move to say that you can't challenge jurisdiction. Well, here's the thing, everybody. If you're caught in something like that, subject matter jurisdiction can't be waived. So whether it can't be waived. So this thing of trying to waive that is just... Yes, you can waive personam jurisdiction, but you can't waive subject matter jurisdiction. And subject matter jurisdiction is tied right into personam jurisdiction because they're saying that the Constitution and Code apply to you because you're physically in Wyoming and created an obligation to do or not to do a certain thing, like what the law requires. So if you can't prove the Constitution law applies because you're in Wyoming, then you can't prove subject matter jurisdiction. You certainly can't prove personam jurisdiction. And so since subject matter jurisdiction can't be waived, it's kind of a problem there. So what scares you, other than the fact that these guys are antisocial predators, what scares you about the process? And so what questions can we address or concerns to get you better prepped for this tomorrow?
Okay. Yeah. So what scares me is I just bonded myself out yesterday. So, I'm scared of him throwing me back into the, jails and just leaving me there. And then I'm stuck back at step one. And what I'm scared is, I don't think these people around here, these judges, have actually come across people like us that are actually going to stand up. So what questions I got, is like, when I'm coming up and say, my intention is to plead guilty, has the prosecutor presented any evidence to prove the constitutional laws of the plaintiff state actually apply to me and that there is jurisdiction over me? What's this judge going to answer me? What are you talking about? So then I'm like, oh shoot, well, I didn't prepare for this. I prepared for, objection, you're wrong. Your jurisdiction is not a trial issue only.
Okay,
how do I know that? And like I said, going from your video.
But remember,
what are these questions I got to ask, or how are these questions going to be answered from my point of view? What baseline do I need to stick on other than
you haven't done the role playing? You haven't done any role playing with this, have you? In the No State Project Skype chat,
I haven't.
You need to do that after the show. They always have a marathon session. You let the guy. You contact me at Frank Rizzo 3. I'll put you in there, and then let the guys know, hey, I'm the guy from Wyoming who's on the show who's not prepared. So we'll still do some role playing, because one of the things I noticed, and you may not meant to do this, or you're just talking because you're not actually there. Don't make statements. Okay? It's always in the form of a question. I know critics will turn around and have a field day. Yeah, it's really just... The fact is, linguistics and grammar mean things. It's the way we structure our ideas and the way we communicate. So it's more effective to say that there is a conflict of interest by bringing it out into questions and having them say it than to just have us make the statement. So instead of just making the accusations, which is not an effective way to defend yourself, we ask questions. We ask leading questions. And so keep that in mind. You're asking leading questions whenever possible, which is most of the time. They're yes or no questions, and you're supplying the information to the judge. So let's go back. It sounded like you were on the line that thinking that What do I do if I'm asking if the prosecution has presented sufficient facts to support their claim that the code applies because I'm physically in Wyoming, and the judge is going to play stupid? So and that's a common thing where the judge will try to gaslight you and make you feel stupid. You say, what are you talking about? And you just, well, sir, you don't understand. Has the prosecution presented sufficient facts to support their claim that there's jurisdiction over me?
Mm-hmm.
You know, so you can make it a little more vague there instead of saying as much. The Constitution, you know. So have they presented sufficient facts to prove that there's jurisdiction to even have an arraignment? You know, that there's jurisdiction over me to even have an arraignment. That then now he's just got a yes or no answer, and so what they'll usually do is just say, sir, we're not here to discuss anything like that. I'm here today for one purpose and one purpose only. How do you plead? And he may do that. And that's when you can say, if he says it like that, well, objection, sir, I intend on pleading guilty. Has the prosecution presented sufficient facts to even justify an arraignment? Okay?
Okay.
So if he's going to play hardball with you, you want to actually get out in an objection, and say, objection, you're seeming to get, if there's some reason you're getting very upset and it's making me really nervous. I don't understand why you can't speak to me like a calm, rational adult. I intend on pleading guilty. Has the prosecution presented sufficient facts to prove jurisdiction, yes or no?
Okay.
So I guess we have to look at what the hell do you do if the judge absolutely will. So we'll just do a worst case scenario that you're afraid of. And a worst case scenario, he could say, you either enter a plea right now or I'll put you in jail. That typically does. It's usually if you don't enter a plea right now, I'll enter a plea of not guilty for you. That's usually the way it goes. So let's address the two of them. If he does say, if you don't enter a plea right effing now, I will put you in jail. Just say, under threat, duress, and coercion, you got not guilty, tough guy. I'd like to go. And then you file your motion to recuse the judge and to strike the plea because he coerced you.
Okay, yeah.
Okay, so what do we do in the more likely scenario where he says, if you do not plead guilty or not guilty right now, I will plead not guilty for you? How do you respond? What is your impression? What do you think that you should do in a situation like that if he throws that at you?
Say exactly what you just said. Under threat and,
Well, no, he's not threatening to put you in jail. He's just saying if you don't enter a plea of guilty or not guilty or no contest right now, I will plead for you.
Oh, I would obviously say, I'm trying to plead guilty right here, Your Honor. But before I do, can you help me understand? Am I going about that wrong, or how am I?
Well, a couple of things. First, we always want to say objection, and never, ever, ever, ever call him Your Honor or her. It's always ma'am or sir. We're still going to be polite. We're still going to be professional, and we're going to treat them the way we want to be treated. We want to treat them with the same courtesy that we expect, even if they're not giving it to us. It's irrelevant. We're going to hold ourselves as rational professionals, adults, and we're going to extend him the courtesy we want extended to us. So you say objection. I'm trying to plead guilty. And then just ask the question again. Yes or no, sir, and this is over. Yes or no, has the prosecution submitted sufficient evidence proving jurisdiction over me? Now, you've seen the video. You know what we need to do if the judge just pleads not guilty from this point. If he pleads not guilty for you and tells you to get the hell out of there with a pretrial date, what has the judge just done?
You just broke the fundamental rules.
What
fundamental fairness?
Right. He's done, and how so?
Because he entered a plea over my head, over my objection.
He not only entered a plea over your objection. He is he being honest in the way he's doing it?
Yeah, no, he's not, and he's taken it went up under my mind, but he's taken responsibility for the plaintiff not presenting any evidence. Is that right? He's taken
right?
I forget what.
So there's a few things going on here. He is covering the prosecution's lack of evidence. He's not being straightforward, so you can enter a voluntary and intelligent plea, whether it's not guilty or guilty, but we know clearly you're trying to plead guilty. And yes, even with a guilty plea, it has to be voluntary and intelligent, which is why they have to interview you. The other thing he's doing is he is lying, and he's basically falsifying the record, because the only time, this is for all the new people listening, and I do appreciate all the new people tuning in, the only time the judge has authority or discretion to enter a plea on your behalf is if you are refusing to plea or they cannot ascertain your plea. So when he goes ahead, and let's say he does this, Jeremy, when he goes ahead and enters a plea of not guilty for you, he is lying and falsifying the record that you're refusing to plea when you're clearly not. So so you're right. He is violating fundamental fairness. He is violating due process. He is generally being a douchebag. He's being a typical dishonest, antisocial parasite. But yet those are the specifics of what he's actually doing. So just real quick, when someone says, but he knows you're not intending to plead guilty. You're just playing a game. Wait. So he knows. So because you're just playing a game, that equals refusing to plea, and because you are refusing to plea, he can enter a plea of not guilty for you. Well, that's nonsense. And of course, I want to explain for people who are new, it's nonsense because the judge has to make sure that you're entering a voluntary and intelligent plea. To do that, he has to inform you on certain things. The prosecutor has a burden to prove jurisdiction. No one else has that burden. Not the judge, not you, not me. No, it's the prosecutor or the police officer, who's ever acting as prosecutor. That has to be proven before they can have an arraignment and send it to pretrial. So it's a basic question that goes to you having enough information to enter a voluntary and intelligent plea. Now, we always hold out that this is damage control. If many of people have gone through and done the plea of guilty because they threw him a smoking deal. But you still have to know if there's jurisdiction to even entertain a deal. So it's this BS. It doesn't hold any water when they try to make a claim. Oh, he's just playing a game. No, you have an obligation to establish whether the prosecution has sufficient evidence so that you can legitimately and constitutionally proceed against Jeremy or whoever it happens to be. Okay?
Okay.
So I'm running. We can take one more question because I got a full boat of calls.
Okay. Well, I just wanted to verify with you the ways to go about getting the next motions, because the only one I have is a motion to dismiss and strike the plea. I think, but I tried to look everywhere on your website to see how I can, get it. Do you have like the motion to strike the plea and disqualify the judge? But I don't know where about to get that. But I'm pretty sure I can just email you, and we can talk about that later.
You just have to email me. I don't send it out with the initial motion package. I send that out as people need it. I don't want to overwhelm people. So just email me, and I'll send you the templates. On the other side, have you filed the Brady request, the discovery request?
That I haven't. That was going to be my next question. What other motions do I need to hand in, file before I go about anything else?
Well, you need to have
there was motion discovery and...
Yeah, you need to have already filed a motion to dismiss, and you've got the discovery request that goes with it. So it's a little late on that, but not as long as you got the motion to dismiss that's been filed, that's great, because what you should be doing when you first get in there is seeing if the prosecution has evidence to overcome the motion.
Okay.
Okay, and so real quick, when you're in there, if he just denies it outright, you have to object, and you're saying objection. So your position is the prosecution has submitted sufficient evidence to overcome the motion. Because that's the only way to overcome the motion. Unless you're going to argue the motion is legalistic gibberish, which unless you're filing into unless the U.S. attorney is involved, they probably won't use that. So remember that.
Right.
So
doing it right then and there, the arraignment, or because last time I did it, I just went to the courthouse and went through the clerk and just entered it in.
Well, tomorrow you should be seeing the judge because you've got a pending motion to dismiss. They're not supposed to take a plea when they're, and again, if they're going to be adamant about it, you have to say, I am not refusing to plea. I'm prepared to plead guilty. However, there is a motion to dismiss in play here. Doesn't that have to be ruled on before there is a plea taken? Which is the way things work. So,
okay, yeah, I think you misunderstood me. I haven't put in that motion to dismiss it. I haven't read it.
Oh, you're killing me. Oh, Jeremy. Well, bring it with you and let them know you've filed your motion to dismiss. There's a motion pending, and at the very least, they have to continue the arraignment so that the prosecution has an opportunity to respond. It's not proper for them to take a plea when there's a motion to dismiss at play.
Okay, so do that first thing at the courthouse tomorrow. Just put it in.
Yep, with the discovery request.
Okay, and I'll arrange that later with you. But alrighty, well let's get on to the next call. I really appreciate you, Mark. Thank you so much.
I appreciate the call and good luck. Get the role playing in tonight and let us know what happened tomorrow.
Okay, I will do.
All right, give him hell. All right. Yeah, we got to do some role playing a little more in advance than tomorrow. Well, tomorrow being the court date, so try a couple weeks or at least a week or a few days in advance to get prepped for that. So because and he's not being paranoid. There's good reason to be concerned about these people losing their minds. We know what happened with Bao, and we're doing what we can to clean that up. But, the damage was done to Bao. He left with medical issues, minor medical issues, but still. And you know what they tell you when you're in jail and you're complaining about having a medical problem? You're in jail. Yeah, that's what they said to him. He didn't report that on the show, so please excuse me, Bao, if that was not something that you necessarily wanted. But it's in the complaint that we're trying to file. You're in jail. Yeah, no wonder Joe Arpaio didn't want to go to jail. He knows he knows that once you are there as a prisoner, you are not human anymore. It is okay to neglect everything about you. Oh, you got a medical issue? Oh, heaven forbid you're a woman. You're a woman and you go in there and you're not giving your feminine products. And yeah, that happens. They don't care. When you go through that door, unless you are an employee of the state, they don't give a damn. You're in jail, which means you are not human to us. We don't have to have empathy for an inanimate object. We don't have to give a damn. We separated you from your family, from your life, from your job, from your circle of friends. We did it without your consent. We don't need your consent. We don't give a damn. And if you've got a medical issue, aba fangul. So maybe this will get some attention on the prison system, the jailing system down there. That's horrific. He was locked down 24 hours a day, which was more than those animals in Calgary did to Jermaine. Yes, someone is mentioning here the Stanford prison experiment. We know they turn into, we know how they treat them. And it's sick. You're in jail. So remember that. They don't give a damn. We are not human to them. We're going to go through a new caller. Looks like we got a lot of new callers today. We have area code 412. You're live on the No State Project. What's your name? Where you calling from?
Hi, Mark. My name is Kevin. I'm calling from Pittsburgh. I called a couple weeks ago. I just wanted to ask you another quick question.
Sure. I'm sorry. Say your name clear.
It's Kevin.
Oh, Kevin. Calling from a different number.
Yeah, I had a... Pardon me?
No, I'm just saying you're calling from a different number, but tell us what you got. Hopefully it's some good news.
No, I didn't do anything yet. When I called, you told me to file the appeal and file an appeal brief and a motion for post-conviction relief to vacate the judge's decision. I went down to clerk of courts, and they told me all I had to do, they gave me a piece of paper and has like 5, copies underneath, carbon copies. They told me I just have to fill that out, and they'll give me a court case downtown. And I asked about filing an appeal brief, And the lady said, I don't even know what that is. You just have to file this, and we'll give you a court date. And
well, maybe what they're doing, Kevin, is they're going to just give you a new trial. So maybe it's like West Virginia and a lot of other places when you appeal some of these minor traffic or minor, low-end misdemeanor stuff, they automatically give you a new trial or a trial de novo. So that's probably what's happening.
Yeah, I think that's what they do. And so I was just wondering, should I still file the motion to vacate the past judge's decision, or should I just file a motion to dismiss once I...
Well, find out first. Because if they're doing a trial de novo, you don't have to file a motion to vacate or post-conviction relief because it automatically vacates the prior decision anyway.
Okay.
So, but you got to know for sure. So I'm just some schmuck on the internet. I don't know for sure if that's what it sounds like. But you want to call down there and say, hey, have I been given a trial de novo instead of an appeal? And they'll probably say, well, yes, it's a trial de novo and you'll have a court date. So what you'll do is that'll vacate everything that happened before. And then what you want to do is refile the motion to dismiss and the discovery request because everything is starting over again.
Discovery request. Okay.
You should have that already, right?
No, I don't have a discovery request. Do you sell that on your on the website?
Yeah, just contact me at Marc Stevens, let's say Frank Rizzo 3 on Skype or markstevens@mail.com, and I can email you that.
Okay, I got one more question. Whenever you serve it, I'll serve like a motion. Like, do I have to give that to take one to the prosecutor's office and send one to the cop? Is there anyone else I have to give that to?
Yeah, you always have to give plaintiff's counsel a copy of everything you file. So for those who are new, and if you get the motion to dismiss or anything from me, I'll always have the instructions with it. Everything we file with the clerk of the court, we have to then provide a copy to the plaintiff's counsel. So here, it's going to be, I don't know, was there a county attorney? Was there a district or a prosecutor assigned to the trial court proceeding?
No, the first hearing I had, it was just the cop and the judge.
Okay, so, and since this is not an appeal, it's probably still not going to get assigned to a prosecutor, but until the time it is assigned to a prosecutor, you don't serve, you mail a copy to the police officer at the police station.
Okay. And
then if they assign a prosecutor to it, then you only send the copies of everything to them. You never, this is for everyone who's new, once a prosecutor is assigned to the case, you have to cease all communication with the police officer because you don't want to be charged with tampering with a witness. I know it doesn't, they can still charge you with it. No one's had that happen yet, but we always hold out that somebody's going to screw up and they're going to do something like that. They're going to punish them because I'll tell you, cops don't like getting that court paperwork. They've told me directly, don't you ever effing send me court documents again that goes to the prosecutor. Like, that was actually in Iowa where I had a cop just irate with me. So I'm glad that he didn't take his anger out on the client.
Do I mail it to the cop before I go to the clerk of court, or do I file it at the clerk of? Do I do it all like the exact same day at the same time?
I always mail everything, Kevin. So you mail everything at the same time. So one okay. Envelope is going to the clerk of the court, and the other one's going to the cop at the police station.
Okay, that sounds easy enough, I guess.
Yeah, if you have any questions, let me know. And call down at the clerk tomorrow and find out if that's a trial de novo, so you know for sure before you start filing things, all right?
Okay. All right, thanks a lot, Marc.
All right, no problem. Appreciate the call. Kevin in Pittsburgh. We're going to move on. We got area code 509. You are live on the No State Project. And what's your name? Where you calling from?
Yeah, my name's Steve, calling from Spokane, Washington.
Spokane. And I don't know what's going on. I'm missing the name. What was your name? I'm sorry?
Steve.
Steve from Spokane.
Yes, sir.
Okay. You got good news for us?
Yeah, we got good news for you.
Cool.
We purchased your your motions and stuff. So now we're going to go back at it. I'm calling for my stepson, who has had 3 appearances so far. They've wrangled him through, forced him into a plea. He's received a scheduling order ultimately for a jury trial on the 22nd. So he's got requirements for discovery on the 23rd of February. March 8th, he's got to have briefs completed, stuff like that. So I think I just heard you say that you resubmit everything. So we're going to resubmit everything on your forms and see what the response is going to be. But I didn't know what effect it had, since we're already almost into the trial phase, and we're not in the arraignment phase anymore.
Well, jurisdiction can be challenged at any time, even on appeal for the first time. Okay. So I don't think that's really an issue. They might, but you're still in the pretrial phase, so you should still be able to provide. And I'll tell you, and this is my thing, is I think this is more important than regular discovery, is the Brady material. There is no time limit on Brady. You can file Brady after the trial. Brady, for those who are new, is any exculpatory evidence the prosecution has that is material to showing, or relevant to showing that you may be innocent. And it's also impeachment information. So if their witnesses are less than credible, less than honest, they have to disclose that to you. So that's a continuing obligation. So there's no time limit on that. They can't say to you, dude, we're already at trial. There is no Brady is a continuing obligation. And anyone who tells you anything to the contrary is lying, because I'm pretty certain the Supreme Court is not going to overturn something like that. There'd be an awful lot of pissed off defense lawyers out there.
Okay. Real quick, the judge gave the prosecutor an opportunity to send my stepson a letter explaining that they do have jurisdiction, in which he just quoted the RCWs. I mean, come on. But that's their come on. Okay. So he's asked for he's challenged jurisdiction to their consternation, and that's the response to him. So we're just going to act like that doesn't even exist, because that's not proof. So we're still at the fact that they haven't answered the first question.
Well, I would give him a call. Look. You've got something specific in writing, and they're claiming the RCW. And I actually have a call of shame. I have a tax hearing that I did where they brought that up, and so you want to address that with him directly. So it's your position that the RCW is proof the Constitution applies because I'm physically in Washington. That's really that. So get some dialogue on it. They, if you want, they may not speak to me, but we could give it a shot. But so if you do call them, you do not discuss the merits. You just want to discuss the discovery response he gave and get him to. Because you can even ask, as your leading question, isn't the Constitution the evidence proven the code, the RCW applies? And so you can show that. So then isn't your discovery response, isn't that contradictory or backwards? Is it really your position that the RCW is proof the Constitution applies to me? And you can always ask them, how does the code prove the Constitution applies to me and creates obligations? Can you explain that? And can you give me some of the details that your witness is going to give on the stand to explain that?
Okay. Did you say that you would be interested in having a call with him?
Well, I've done it before. Yeah, I've done it before. I've spoken. In fact, you can go and you can hear call of shames that I've done with prosecutors, and, whether in and out of the United States. So, MarcStevens.net, for those who don't know, the call of shames generally have calls to prosecutors where I'm asking them directly questions like this. It was a Washington prosecutor that was insisting that the laws apply just because somebody was physically in Washington. And I asked him, well, could you explain to me, how does that work? How does my physical presence in Washington prove your laws apply to me? And she says, it just does. Right. It just does.
Oh man. Yeah. Okay, so use that. to our advantage as far as, I mean, I don't have to ignore it. It's because it's just proof of them being ridiculous, but I'm not worried about it.
You shouldn't be. I wouldn't be. I would just make sure that if you make the call, you're very confident and you've done some role playing and you're confident in your ability to go through the Socratic method with them and have them bring out or at least admit that what they said to you in the discovery is not true. That they haven't provided you the evidence, which is fairly easy to do, provided you just ask you ask leading questions and don't take their BS as true. Don't let them off the hook. Every single bureaucrat I've ever spoken to that claimed that the code proved the Constitution applied, every one of them has either admitted that it's backwards and not true, or they just refuse to speak to me. And you don't have to worry about them refusing to speak to you because you'll be able to file for a Brady violation. And then you'll be able to put his own language in the motion to dismiss for prosecutorial misconduct. So you get your Brady violation and you've got your misconduct in that they're arguing without evidence. And here he needs a psychological examination because he thinks that the RCW is evidence that the Constitution applies. Come on.
Okay. And the notes from that meeting or that call, they're allowable as information to present outside of that? I mean, because if I'm going to hit him with a Brady violation, what proof do I have that he made those statements at all?
Well, all you really need, it would be great. Well, it's your word against his. Okay?
Right.
But all you need is his discovery letter saying that the RCW is proof the Constitution applies. That's backwards. It's ridiculous. That's insane.
Oh, yeah. He's still short. Yeah, he's still short at that point. He still is, that's still prosecutorial misconduct at that point.
Yeah, he's arguing without evidence. Because he's not presenting any evidence the Constitution actually applies. He's only presenting...
Still his opinion.
Opinion and irrelevant information. The RCW can't possibly be proof that the Constitution applies. Because did he give you an explanation? Did he at least try to cite where in the code it says this code is proof the Constitution applies?
Yeah, he gave the specific RCW.
But does that RCW actually say that the Constitution applies to you?
No.
Of course not.
No, it's right back to the whole thing that it's the statutes and codes apply.
Yeah, but there's nothing in. Yeah. I'm just making fun of his response. So you're able to put in there that even because I've done the same thing. I've quoted. I said I'm going to actually read the statute. I want you to stop me when I get to the part where it says that it's evidence proving the Constitution applies. And I'm like, you don't have to read it, really, because you already know that's not what it says.
Yeah.
That's one of the few times I'll actually argue and discuss what the statute actually says when they do something stupid like this. So you could just bring out the RCW is not proof that the Constitution applies. The RCW is proof that the code applies, which we're asking for proof that the Constitution itself. So you can even go right in the Constitution. It's like, I don't know where it is, but like the U.S. Constitution, all legislative powers herein granted, so they'll have the same thing. It's right in the Constitution.
That's in 1.1 of the Washington Constitution.
Okay, well there you go. So he's getting it backwards.
Right there.
So he's even if we consider his information, which it is information. Even if we consider his information, it's not that he's presenting. It's not information that's relevant to proving the proposition, is it?
Okay.
So it's not evidence. So his information is not actual evidence supporting his claim. It's just information, but it doesn't prove the claim. So, contact me off air. I'm going to try to get to another couple of calls before we're out of time today. But contact me off air.
We'll do.
And we can set up if you want me to help doing that. So.
Very good. Thank you very much for your time, sir.
Oh, you're welcome, Steve. This sounds like a horror story. I believe this is Emily. Do we have Emily from area code 864?
Yes, this is Wanda Ann. Hi.
Hi, welcome to the show. I'm sorry to hear. I mean, and Matthew from Down Under, I appreciate this, mate, was letting me know that you were in the queue and 55 days in jail for for driving without a license and tags and resisting arrest.
Correct. I'm a vicious woman. I'm 79 and a half years old, young. And they did not want to hear me say that my property, that it was a private car. They were breaking and entering. They did not like me saying that I invoked the Fifth and have no counsel. So I gave him no materials. He just got pissed off.
Were you doing right to travel, Emily? Were you doing right to travel stuff?
No, Emily is my friend.
Oh,
I'm
sorry.
Duran.
I'm sorry, One Duran. That's
Emily
right.
on too?
No, so were you, One Duran? Were you when you're talking about a private car and whatnot? Were you doing right to travel type stuff, that you were traveling and not driving?
I did not bring that up to him. I just brought up I had on my plate, private, do not trespass.
Yeah.
And I did not have any driver's license or registration. I did not contract. I did have insurance.
Okay.
I did not talk to him loudly. I hope I'm not talking too loud now.
No, not at all.
I don't hear.
I don't have much time here, so I apologize to everybody else on the line. Saturday, 3 hours, Anarchy Radio, so hit me up there. So Emily will be the last, Wonder Ann will be the last call today. We made it almost an entire show on the Wednesday broadcast, episode 52, without any mention of right to travel contract type stuff. And I'm not, look, what the cop did, we're not going to excuse that. Okay, just last week I reported that I think there was right here in Mesa, Arizona, where the fortified compound is, hails from. Someone's grandmother was assaulted by Mesa PD and had to go to the hospital. And they had specifically told him about her condition, not to bother with her, and they did anyway. And so they wound up putting this older woman into the hospital. So without excusing that, I do have to mention that there are men and women forcing us to pay them. It's all compulsory or go to jail. There is no contract. They're not trying to trick you. They're forcing everyone at the barrel of a gun. Yes, we're all forced. So I can see the trolls coming out now. You get the license or you go to jail. As you know, you didn't have a license, and I'm not saying that there's evidence that you or anyone is required to, but you got arrested, didn't you?
I got arrested. I went to the detention center, and I was actually attempting to follow this one person's method. And because I'm too old for them to be really losing a job or family or anything like that, I just didn't want young people to do this. And so I pushed his envelope, and I didn't give my name. I just held back information. I didn't let them fingerprint me. And then I learned that they do not have a 72-hour thing. They can keep you ad infinitum.
Yeah.
And they don't care. And what you said about female materials in our pod, they gave us enough toilet paper for 3 men, and we had 64 women in there. So you know that some of that is very true, what you were saying. The other side of it, I did get sick, and they did put me in the what I call the infirmary, but it's really isolation is what they call it. It was filthy, absolutely filthy.
Oh, sure. Yeah.
So,
well, let's get this terrible 55 days.
And let's. I know.
But let's and so when they said, because this I'm as far as the resisting arrest, what was that? I mean, did you physically resist being handcuffed? I mean, what is the basis of these animals saying that?
He said it because I would not unlock my door. They broke the window on the rider's side, and sprayed me with glass, but I turned my head so I didn't get hurt. The officer on the rider's side flipped the lock. The cop on the actually my side of the car reached in to pull me out of the car. He forgot to take off the seatbelt. So that's the grounds for my resisting arrest. And I didn't come out when he said, "Come out of that car." You know how they do that. And I didn't come out of that car because I was in my private automobile. And I told them they were breaking and entering if they broke the window, and they broke it anyhow. And the other officer unlatched my belt. So, and my hands, I had moved here from California in '03, and we had to put our hands on the steering wheel. So everybody saw your hands had nothing in them. And that's what I was doing. And he's saying I held on to the wheel. Well, I was in gloves. It fell off. It is just his inability to get me out without the seatbelt on.
Where did this happen?
Pissed him off.
Yeah, where did this happen?
This happened in Greenville, South Carolina. And I live in Spartanburg, which is what they call down the road a piece here in the South.
Yeah, so I would point out that not only is it not a contract and never to discuss things like that, I would not travel without a car that had the tax tag, an up-to-date tax tag on it. It doesn't have to be in my name because I don't have a car in my name, but it should be current because they're just too violent. I mean, you're lucky, to be alive with these animals.
Correct.
55. All right, so always have that, unless you're an activist. And if you're an activist doing it, more power to great. Just let us know so we can do a habeas corpus in a situation like this. But unless you're an activist, you're going to have to identify yourself, or they're going to do things like this, like breaking windows and possibly hurting you. So for those not activists, give the identification and then tell them on advice of counsel, I'm not answering your questions, and just keep your mouth shut. On a traffic thing, unless there's with yours, they may have just left you on the side of the street and just stole your car. But you wouldn't have done 55 days in the gulag.
Right.
So have you had an arraignment on this yet?
Well, they my 55 takes care of the actual penalty, but I have a court appearance on March 5th. Now, I did download from one of your other people that you have this dismiss, and I've got that printed out so that I can adjust it to my information. However, what I did in jail, and this is my lummox, is I signed up with a public defender because I thought I'd be going before a judge while I was still in the detention center.
Okay.
So what do I do to get rid of the PD?
Well, he's going to have to withdraw, or you fire them, and ultimately the judge is responsible for letting them go. So you may want to keep them on as standby, just so that so that you can still defend yourself. Which wow. I would file the motion to dismiss as soon as you're able to. File the motion to dismiss and a discovery request. But the 55 days, you haven't been convicted of any of this yet. You did 55 days, but it's not because you were convicted, right?
Well, I don't know what it is. They kept me in jail. As far as I was concerned, I looked at it as being a political prisoner. I am an activist, if you want to have it bluntly said, and because this is not the first time I've done this, but it was in Spartanburg, and they only keep you for 6 days.
Well, you got to get more information as to why they held you for 55 days. The only thing that's coming out to me, based on what you told me, was that you wouldn't give a name and you wouldn't give the fingerprints. So they could have just been really callous and just say, we don't care if she's 79 years old. She doesn't comply. She's not getting out. They could have just forgot about you. So did you give fingerprints? You probably had to give a name and fingerprints eventually, though, right?
Oh, I gave it within 2 days. I gave it to him on the 17th of December because, for just what you're saying, that they were just going to totally ignore the 72 hours.
Well, there is no. I think that's an urban legend that they, it's just not something that they are held to. I mean, it's just like they're supposed to be fair. Judges are supposed to be fair, impartial, independent decision makers. That's an urban legend. That's, they're supposed to give you a fair trial. Another urban legend. So I'm pretty much out of time. So what I would suggest before, really getting into the issues, well, first, drop all the right to travel stuff. Never do any of that. That's number one. The other thing is, get back to me after you talk with the public defender about them going standby, because you'd like to be able to speak for yourself, make objections, do cross-examination, and file your own paperwork.
Well, part of the problem with this public defender, even my son attempted to get him, and one of my friends attempted to get him. He never responded. So what do you do with that? March 5th is just, 10 days away.
Then you're going to have to file a motion to fire the public defender, to have him removed, because for ineffective counsel. He's not responding, he's not actually defending you. And maybe that's something that the judge will take serious. They may want to just get another public defender, but at least you might get somewhere that way. So that's what I would do. I would file that motion for ineffective counsel, and that you want to defend yourself with standby counsel. So I'm completely out of time, so I got to let you go. So get with the public defender first and see if. Give that one last try, document the time and day that you call so that you can put that in the motion to have him thrown off.
Okay. And I appreciate you taking me, and I will get all this done. And if we can talk on Saturday, I'll get back on and what and where and how.
Sounds good. Yeah, just go to markstevens.net for the times.
Okay. Thank you very much, Mark. I appreciate it. I've listened to so many of your videos. I so agree with what a lot you said. Thank you.
Well, I appreciate that. Thanks for calling, and hopefully we have good news next time that Wonder Ann from South Carolina calls. And we are completely out of time for episode 52 of the big broadcast here on my YouTube stream. Remember, Libertopia 2013 just around the corner, May 3rd through May 6th, libertopia.org. Check that out. If you do know a place here in the East Valley with the great Wi-Fi, and they do an open mic, I'd like to I'm still looking to do the show at a live place here in East Mesa. So if you know of a place, contact me at markstevens@mail.com or frankrizzle3 on Skype, and hopefully we can get that set up. And if you're being attacked by a bureaucrat, by all means, contact me at frankrizzle3 on Skype, and we can get you into the Skype chat so that you can get to do some role-playing. So don't do what our friends, some of the previous callers have done. I think it was Jeremy in Wyoming. Don't wait till the day before. Still, it's going to help. It will help, but you're better off getting a few more hours worth of practice in before you go in for an arraignment. Again, my name is Marc Stevens. It's been episode 52 live from the Fortified Compound here in Mesa, Arizona. I will be live on the Saturday broadcast. So till then, salud.